So let's endeavor that by no later than 5:15 we'll wrap this up, so that this is all that separates us from the cocktail hour. And one more time with feeling, I am sure that there are going to be a lot of great ideas that are spawned from this and from what's been said today. So you'll have an opportunity, if you don't get to ask a question or you think of something over a drink, I'm sure our panelists will be very gracious to answer anything you have. So I'm not quite sure how we best go about doing this, but let me just throw out a couple of themes that I sort of took that were common themes from today, and maybe each of you, if you wouldn't mind, would sort of give your thoughts in terms of some takeaways and some of the things that maybe we learned today. So one thing that clearly seemed to be a predominant theme was culture. That we talk a lot about change, but we talk about technology, all these other things, but it's really ultimately a footnote to culture. So let me start with a question that I throw open to anyone who would like to answer. What do you see as sort of the biggest impediments to driving true cultural reform in the legal profession/industry? What are the biggest roadblocks to to creating a new legal culture?
Well, I would go.
Eva, please. Thank you for volunteering.
I'm the brave one.
Thank you.
Okay, I would say that one of the biggest problems that we are finding when trying to change a law firm comes from the business model itself, the way that lawyers are rewarded. If you reward your lawyers based on the billable hour and the number of hours they have to work every year, 1,900 hours per year, it is very difficult to change this. If you do not change the way the lawyers are rewarded and measured, you cannot change anything else, because they will do exactly what they are paid for. If they are paid just to bill hours,
Yep.
This is what they are going to do. And if you try to change the way they deliver the services, and it's a way you want to deliver in a way that is more effective, it goes directly against this.
So it's how lawyers are evaluated and how they are rewarded.
Yeah.
Johan, you had something.
Yes, I have a practical example to share with with the crowd here. Is that to illustrate what Eva said, is that I shortlisted several law firms for a European-wide project, and one of the criteria for the RFQ was, I would like you, law firm, to use an AI platform to review thousands of contracts, right? One of the firms replied to me, well, we are very good lawyers. We don't need this. Okay, so they were out, right? So other law firms said, okay, we have a platform, but do you really need, do we really need to go through that process and involvement of the AI platform? So I could really feel from law firms that have been using this type of platform, like Kira system in that particular case, a reluctance to actually use this platform instead of having an armada of young associates spending hundreds of hours, billable hours, right, on the project. So I think I could really feel, so recently, how reluctant law firms are to using AI platform due to this business model constraint.
So let me ask a question, because John had talked about the importance of structure, which I completely agree with, and Crispin, certainly from a regulatory perspective, is doing everything he can to say, let's open the floodgates to structure, right, and leave it to lawyers to regulate the narrow regulated practice areas. So let me pose this question to the group. Why do you think it is that legal buyers, who ultimately now hold the power in the balance of power, why do you think legal buyers are not either putting more, and this will be with reference to U.S. regulators, aren't putting more pressure on U.S. regulators to say, hey, why are there these kind of very arbitrary constraints regulatorily? Why don't we do, create an open, more re-regulated market that allows other structures?
So as an outsider, actually it's no different anywhere else in the world, really. And it goes back to the earlier questions about culture. New ideas come from diversity. They come from talking to people that are different than yourself. And decision makers at the top of law firms, the only way to get to the top of a law firm is to start at the bottom and work your way up. And any sense of creativity is hammered out of you over many, many years of assimilation. The point about structure as business structure is it allows different people to come in straight at the top of an organization with different experiences. What John's done is from experience built in different areas and coming into the top of the law firm. The trouble with buyers is that the way they become senior buyers of legal services in corporates is by rising up in exactly that same culture.
Yep. John, you had something.
Yeah, I was gonna, with the first question, and I'm glad that Christian brought it up, because I think one of the biggest impediments to culture change is the lack of real diversity in the people running law firms and operating with them. And I think and that's not just male, female. I mean, it's just a much broader kind of inclusive society that we experience is not the same as, if you look at most law firms, they don't look like the rest of the world, right?
Right.
So I think that's part of it.
Or even the businesses that they often represent.
Exactly. So, and it's the people, but it's also not just demographics, but it's their expertise. And that gets to the structure and being able to have a truly dynamic company that brings in all those different skill sets at a level that are attractive. It's hard to attract really entrepreneurial, strong business acumen, those kinds of expertise in different talent areas. If you're in the private sector, if you can't have an ownership interest,
Right.
I mean, for the real entrepreneurial people who are driving businesses, they want to build something that they can actually own.
Right.
And if you want to help create wealth, I mean, all that. So I think the structure issues do become a problem, and they're connected to the lack of diversity in terms of creative problem solving, because you can't get that mix of really high-level talent in the room working together to create some new ideas and help serve clients better.
Yep. Dan, you wanted to.
I want to make a point about lawyer regulation and law school regulation. It's a real puzzle. Lawyer regulation is by and large self-regulation.
Right.
By lawyers. And so why buyers don't have much of an influence is by and large the judgments and structure. It's a good deal different in the UK and most parts of the world. It's a real puzzle, and to get at that, let me mention something about law schools. Law schools are also largely self-regulatory. Although over the years, thinking about the role of the ABA Council in regulation, it's actually been, and I don't know the exact origins of this, Barry would know, but for a long, long time now, the edict, as it were, has been that the council, acting under the authority of the ABA section on legal education admissions to the bar, has been not exactly Noah's Ark, but it has been required to have actually the input and the membership by not just law professors, but by other folks from within the profession, practicing lawyers and the like. And indeed, I believe it's the case that there's actually a mandate that the chair of the council rotate between law professor and a non-law professor. I'm not positive about that.
Customary, but it's not
customary. So here's a real predicament from the vantage point of law schools. On the one hand, in the profession, we decry that because it's lawyers regulating lawyers and self-interest and the structural, I think answering both of your questions, culture is hard to change because lawyers are regulating lawyers. Why doesn't that change? Because we fear that the alternative is even worse. Because the alternative from the vantage point of law schools and lawyers is to allow public regulation in the form of legislatures mandating those decisions. So we're really between a rock and a hard place. We fear lawyer self-interest that encrusts regulation by having lawyers acting in the name of self-interest. But do we want Betsy DeVos?
Right.
And Congress and the California legislature regulating the legal profession? That doesn't sound great either.
So let me just go back to diversity because I think it's appropriate that we started with culture and talked about diversity because in my mind, diversity is not, as many people think of it, as a kind of a quota or box checking exercise, but diversity is really a statement of what an organization or a society or a culture, what are the core principles and precepts by which it's going to define itself. And I'm just wondering, those are things that don't often, occur quickly. They take time, unless, of course, there's some sort of a cataclysmic event, like one society is literally taken over by another, after a war or something. So I'm wondering, for those of us who are impatient, count me in as one, what, if anything, can we do from the inside? We talked about outside forces that are starting to drive changes in the legal profession, but what can we do as a group of, people who are sort of thought activists and doers to, if anything, to accelerate that process? Dan, let's start with, you as an educator. I know you've agitated for more diversity. I know you're very open-minded. What do you think that the academy can do to stimulate that beyond what it's already done?
I appreciate the shout out, but I am by and large the impresario and the messenger in my role as dean and my role as a legal educator. And the wind is at our back. Not fast enough, and it took a long time. But in the academic world, the legal academic world, I think with some exceptions, we've come to understand the imperative of the twin role of diversity and inclusion, because I think the way you put it is exactly right. The advantages, both self-interested advantages and selfless advantages from the vantage point of the legal academy by having a more diverse profession and acting in various ways to do that. I think that when I say the wind is at our back, I mean I think the demographics of legal education, 50-50 men and women, has been for some time. Slower with respect to race and ethnicity, but it's working in that dimension. But that just, of course, shifts the focus as folks to my left would be able to shed light on better than I would about the glass ceiling and about the
right.
about the melt off in large law firms. And we pontificate to some extent about that in the legal academy, but that's really about difficulties in practice. We want to be part of those collaborative solutions.
Got it.
But we have the work cut out for us in dealing with it within the academy itself.
And John, let me direct this to you, and not, of course, with reference to your firm, but as someone who is in the vanguard of delivering legal services on a global scale and in a very broad way. The recent data shows that female lawyers now are making 89% of what their male counterparts do for comparable work. That's up from about 73 cents on the dollar about 5 or 6 years ago. So an improvement, but certainly not equal. And some of you may have seen in England, and correct me if I'm wrong, Crispin, there's now a new UK law that says that all businesses beyond a certain number of people have to sort of talk about and disclose gender pay and to expose whether or not there's a disparity. And so some big English firms now have gone beyond the technical requirement and have now posted data in terms of bonuses and things, and the results are pretty horrendous. If we were a smaller society, we would say it's a public shaming that would mandate, some sort of immediate course correction. I don't think that's going to happen. For example, I think most of the Magic Circles firms were showing that women were getting somewhere less than 50% of the bonuses that their male counterpart partners were getting. So my question is, John, what can we do as legal service providers? After all, we're prosecuting, and defending all manner of discrimination cases, but we have a glass house problem. What can we do to solve it?
I think transparency is part of it, but I'm going to take just a little bit of a slightly different take on it. There's a lot about our business model that requires some significant change, but there's one element of the partnership model that is actually good in this regard, in that, you know, all the equity partners know what all the other equity partners are, how they're compensated. There's a lot of transparency as partners in sharing that information, at least it is in our firm. And so, you know, it's not like you can talk out of one side of your mouth when in the other side, people within your firm and your other equity partners absolutely know what the truth is. I personally, I think that, you know, one of the best things we can do is talk about the actual business benefits, the actual economic impacts of having diverse, inclusive teams. And that's not to say that there's not a broader argument, social kind of argument, or just the right thing to do argument. But at the end of the day, it's a really smart business argument. And I think as we're, you know, being able to drive evidence into the marketplace and people see the research around it, people start to emulate best practice, and you can see that. I'm not a big fan, frankly, of you know, publishing all kinds of data on salaries.
Right.
Bill has heard my rant about this before, because you know, I mean, I'm used to having my salary published because I was in the public sector. But I think one of the things that really drove everybody nuts in our industry, especially our customers, is this nonsense of publishing, you know, profit per equity partner and all this kind of crap. It ended up creating an environment that's just toxic.
Yeah, well, thanks Steve Brill back in '87.
And it's toxic, and it's kind of BS too. I mean, you know, you can play with numbers.
Although and you know, and we know that, you know, it's a double-edged sword, because on the one hand with PPP, you know, it's very easy to indict lawyers for focusing on that. On the other hand, many managing partners have told me, well, if I give up on that, then, you know, I'm going to lose all my big rainmakers because they'll jump to some other ship that's got higher PPP.
Well,
so
you don't necessarily have to give up on the concept. Just dare to put a you know, flag in the ground and say, I'm not publishing it.
Yeah.
You know, because, you know, for us, and our firm is somewhat unique, but not totally unique, in that, you know, it's just so arbitrary and ridiculous. I mean, we operate on every continent. Yeah, cultures are different.
Right.
Currencies are different. Economies are different. And to say you're going to have one measure that tracks the average of things across the globe is just, it's irrelevant.
Yeah, and I'm going to, go ahead.
Is the core problem, are we talking about not the actual partnership structure? Isn't that the core problem also in diversity? Looking at, for instance, Wolters Kluwer, and I don't know if she's already here. No, well, there was an old colleague of mine. I think, you know, the teams which worked the best for me were mixed teams. And if I needed to work with an enormous amount of salary partners and things like that, who are also in the influencing and decision-making unit as influencers and things like that, I think it would be much more harder to actually create my own team, which is diverse, with women and men in it. Yeah. And isn't that the problem? One of the problems in this diversity challenge.
I don't know if that is, if there's a direct correlation. I think it may, you know, you can have diverse or non-diverse cultures and teams, whether you're a corporate structure or a partnership or something else. I think there's more to it. I think it may be more about how you hire in at the beginning. And, you know, firms are getting smarter about this, but I think a lot of law firms tend to suffer from the halo effect when it comes to hiring new people, because it's just not as scientific as other companies, and I think some of that's changing as we're getting more sophisticated from a management perspective.
Yeah. One of the other points that came up today, and then I'd like to throw it open to anyone in the audience who wants to ask our panel a question. We'll have a few minutes left. You were mentioning, the idea of daring, and you were talking about success and failure. And clearly, anyone who has been an entrepreneur, or even who pretends to be an entrepreneur, you have to have your uniform dirty. I don't know of any entrepreneurs who bat 1,000. Nobody. Not even Steve Jobs, batted 1,000. Some people obviously have better winning percentages than others, but it just comes with the territory. On the other hand, we as lawyers, practicing lawyers, are trained not to F up. That's our big mission, right? Don't miss that one case. Make sure that you just turn in as impeccable a brief as you possibly can. We always strive for perfection and the avoidance of mistake. So I'm wondering, as we sort of move as both a profession as well as an industry, where you've got one set of people who are engaged in sort of regulated practice activities, let's call it the more traditional lawyer thing, and then we've got a whole new set of people who are maybe leveraging their practice or their knowledge of law with business and technology expertise. These people tend, I think, to be a bit more entrepreneurial. They tend to be a little bit less risk averse. And I'm wondering, how do you see the marketplace in terms of finding opportunities for each of those groups? Obviously, there are those unicorns that transcend the two groups, but what do you think about that?
Well, I think, first of all, I think it's very important that you have those stars, those real lawyers, those stars in their legal profession. You wouldn't have a surgeon who operates you and is very good in thinking about how to reorganize this hospital.
Right.
And what you told us before, you asked him how many procedures did you already did in this specific matter. So I think it's very important that you hold on to high expertise in terms of knowledge of the law, regulation, and things like that. But I think that's also a diversity thing.
Yeah.
Diversity is not
Yep.
only
Yes.
men, women, but diversity is also more entrepreneurial and more traditional probably.
Yep.
And traditional isn't, people tend to say, well, traditional is that's not good. No, traditional in the way of being expert in your field of expertise is very good, but it's all about the mix.
Yeah.
And accepting the mix. And one of the problems what I see globally, and it's not the big law firms because they have a lot of money to invest and try things out, is maybe in the traditional mid-sized law firms where you see that law firm leaders are those traditional lawyers who are much more into practicing law than to building a company or accept new things from outside. And their challenge is really to accept the new lawyer we talked about and embrace this lawyer in their teams to survive. So I think that's very important. So I think it's also a matter of embracing new and mixing it with old. And old isn't by definition wrong.
I'll just make one sort of editorial comment before we open it to questions, which is, I, for one, think that besides the fact that, this is an international group, it is you using your, what I think is absolutely correct, broad definition of diversity. I think that the more we as a industry and a profession can get academics next to providers, next to marketing people, next to buyers, next to regulators, next to media people, and we all view problems as central problems. We're not going to, in my opinion, address law's wicked problems, access to justice, all these other big pressing issues. We're not going to be able to do that unless we really take a diverse view of this in the true sense. And in that sense, I'm really delighted, that each of you has agreed to participate. So, any questions? We have time for a couple questions from the floor, if anyone would care to. And don't feel guilty that you're going to be the person keeping us from drinks. Yeah.
I'm Irish, so I do drink.
Oh, okay.
Going back to the comfort zone, I think just a variation to your question. If purchasing legal services is really purchasing a reduction of risk in a way, and introducing technology always increases risk, there seems to be a problem there, that anybody that introduces technology is going directly against what the purchaser of legal services wants. This is I suppose this is a proposition, not a statement. Do you have any reaction to that?
Well, first of all, I think risk is not an apple. Risk can be an apple, pineapple, banana. So it depends on what you define by risk. If it's risk in being able to deliver the services for 100%, the legal services, the traditional legal services as a lawyer, yeah, I think then you have to look a little bit further in your decision and ask those tech peoples about fail-safe solutions and helping you in creating a solution that you have a fallback scenario so you can mitigate risks. But it's, for me, I see risk as as not as a defined thing like an apple. One thing, risk comes in many forms. So you have to define the risk itself first, and it's something what I hear a lot is, using tech is also embracing risk.
John's got a point.
Just 2 quick points. One is that I think we're quickly getting to the point where the risk might be from a law firm or a lawyer's perspective of not using the technology.
Right.
Because cognitive computing is getting so good and has so much potential. There's already been a couple of pretty well-regarded studies that compared machine learning and a group using machine learning versus non-machine learners, humans. And in many cases, the machine plus people outperforms either one by themselves. So I think there's almost going to be a part of the evolution of our professional responsibility requirements of having some degree of acumen around using these things. The other thing, though, that you said that really struck me, because it goes back to your point, Mark, about a lot of what we do in law is manage risk. And when we think about the delivery of law and some of our business model challenges and the historical perspective, you got to turn over every rock. Well, I think our buyers are very sophisticated, and they understand that their risk management means that certain things you can do differently. Right. Because the risks just frankly aren't that high if I make a mistake. And we can tolerate a different delivery model because we're balancing the relative risk. Whereas there's other spectrums along the legal services continuum that the risks are really high, and you are going to want to deliver in a more traditional kind of deep dive, turn over every rock.
Yeah, but
firms just
hold on.
Firms have to figure out how to deliver across that spectrum and not,
Yeah, you just hold on. I didn't mean to cut you off, but Crispin wanted to add something, and he hasn't been heard yet.
That's right. Just to add that the real risk for most individuals, most small businesses, and even often corporate clients is they don't get any help solving their problem because lawyers are so expensive.
Yeah,
That's the real risk.
Yeah, well, it's the same.
Yeah.
Don't underestimate the difference between big law and small or medium law, because also risk is something else. For you, risk is probably something you try to manage, mitigate, but medium and small law, they define risk certainly different. And it's sometimes for them it's very hard because they don't have the means to talk with those IT delivery people in mitigating risks, and there are not that much off-the-shelf products.
So Eva and Johan have each. Dan,
I had something to say.
all right. Well, let's go Eva and then Johan and Dan. That all of our panelists have responded to your question, or will have responded to your question. So Eva, fire away.
I'll be very short. I come from a jurisdiction in which the legal sector is partially deregulated. It's not fully deregulated like in the United Kingdom. It's partially. And going back to the point of mid-sized law firms, from the last 10 years, I see tremendous change in these mid-sized law firms being able now to have people directly involved and only devoted to managing the law firms, because there are people really prepared to do this. While on the other hand, we have those lawyers practicing law and again trying to manage their law firms. They are not prepared for this. They were never taught to do this at school. They had to do it at night after their normal hours of work. So it's not properly done, and this is more risky. I think that this increases the risk that the client can have, because the risk is not only on the delivery of on the way that you study a case, it's in the way that you manage your documents, keeping pace of all the documents, all the key dates, all these things. You've got to manage all this as well. So I see more risk in not properly manage a law firm.
So you're going with John, that there's more risk if you don't embrace technology, certainly under certain circumstances, than if you do.
Yes, technology is a very important point, but deregulating gives the opportunity to these small firms that do not have the money to invest in a director that able to bring in people to do this job.
So it's a combination of regulation, structure, and technology.
Yeah, I've seen a real change in our jurisdiction thanks to the partially deregulation.
And point of information for those of you who may not have been here, correct me if I'm wrong, Eva, that Eva mentioned this morning that in Spain, her native jurisdiction, non-legal ownership can have a 49% stake in a law firm. Is that correct?
Correct, yes.
Yeah. Okay, Johan, and then Dan.
I would like to come back to the question about technology versus risk reduction. For me, there is no antagonism. As was mentioned earlier, I think that you have studies like by LawGeeks showing that the accuracy of the AI platform in a control review, there is more accuracy in that platform to review NDA than having 10 lawyers doing that exercise, right? Where they didn't spot necessarily all the flaws in the That's one. Second, you have so many startups worldwide. They cannot afford a lawyer, but they want to start a business. So today, in many countries, you have these platforms that enable you to draft yourself, auto edit your bylaws, your charter, get your trademark, and so on. So I mean, talking about risk reduction, I mean, there is a scenario where they did everything by themselves, so they were in a high-risk arena, versus using this platform. It is still not risk-free, right? Because they may not get the right advice how to fill in these forms, but again, I mean, can they afford the risk-free environments? They can't. They want to use their money for marketing to fund other, the future of the business, not the legal fees.
Okay, and Dan, and then I think what we'll do is just going to make a very quick housekeeping announcement after Dan, and then we'll retire and we can continue the discussion outside.
I feel like Northwestern's adopted this policy that we're going to run out of cocktails at 5:20. You see this?
Dan, I'm just sticking to the will of the people, man.
I feel nervous to this.
That's what you really think.
Exactly. Wow. I just want to make a point about it builds on what was just said about the role of technology in reducing a different kind of risk and then maybe this is an argument for robots. That some of the impact of technology is reducing the sphere of human decision making where we worry and fear human decision making. So just to pivot from the lawyering as advocacy we've been talking about most of today, lawyers' role in decision making and actually, substituting for judges and human judgment. Online dispute resolution, the use of predictive analytics to actually make some informed prediction with the availability of big data on how judges might decide, replacing in some areas judicial decision making, which is filled with bias, discrimination, prejudgment, can be vulnerable to it, is progress. And legal search, right? The value added from doing legal search and legal research through the use of AI technology is not with the goal being perfection, but it's compared to what? It's compared to human error, right? That creeps in and profoundly affects how search and research is being done. So that's a different element of risk. Maybe it's more like uncertainty, but the advantages of the use of technology, well used, is to reduce the aspects of human elements that we worry about greatly, because we know that humans are imperfect and have limited cognitive ability, limited ability to process big data. So that it seems to me that it's not inevitable, but the use of technology to reduce those elements of risk, again, the wind is at their back in some important ways.
Thanks. Okay, so I think first of all we should have a warm round of applause for all of our speakers today. So for tomorrow, we've got, as the late Ed Sullivan would say, we have a really big show, day 2. We've got 3 speakers tomorrow. We've got Laura Weingarten, who is here from Toronto. She is an incubatee, her company Diligent, and she was incubated by Ryerson University. We have Marcus Hartung from Bucerius, who, in my humble opinion, might well be even the most, or certainly one of the most progressive law firms in the world. We'll have the opportunity and privilege to hear from him. And we have Andrew Arruda, the young phenom, the 30 under 30. Are you still under 30? I am. Yeah. You are? Oh, okay. Well, there's an example of diversity in our profession that we never had before. 30-year-old, phenoms just didn't used to happen. So we've got some great people for tomorrow. It's a half a day. So we hope everybody will be back tomorrow, and have a good evening.